The 1969 Supreme Court case Brandenburg v. Ohio set a new precedent in the long-standing question of incitement. When a person advocates illegal action or overthrow of the government, is it constitutional to block and punish that speech? What does our First Amendment right to free speech guarantee us? These questions were at the heart of the justice's decision, which produced the two-prong test. In this video, we're going to look into the history of cases and common law that culminated in the Brandenburg v. Ohio decision. Let's begin by looking at the Brandenburg case. The Supreme Court sought to determine if the Ohio criminal syndicalism statute had applied constitutionally. This law prevented advocating the duty, necessity, or propriety of crime, sabotage, violence, or unlawful methods of terrorism as a means of accomplishing industrial or political reform. The water being poured into the glass represents when a law is enforced. If the water remains transparent, that means the Supreme Court upheld that the law did not violate freedom of speech. Brandenburg had been arrested after suggesting that revenge may need to be taken against the government. He appealed, saying his right to free speech had been abridged. The court ruled in Brandenburg's favor. The Ohio criminal syndicalism statute had been applied unconstitutionally. How did they arrive at this decision? First, we need to look 50 years prior to Schenck versus United States. This case was huge. The Supreme Court made its first stab at the problem of advocacy and incitement. Speech, they said, may be limited if it causes a clear and present danger. For the next 50 years, that litmus test, clear and present danger, would be the primary means for determining if speech crossed the line and was illegal. The Brandenburg decision set a new, more specific precedent. How did they arrive at their conclusion? One of the easiest ways would have been looking for a carbon copy case in the past. There was, in fact, such a case, one that the defense argued in its favor. In 1927, the court decided that Whitney, a Californian communist, had violated a very similar law to the Ohio criminal syndicalism statute, only California's version of it. Whitney protested, invoking her freedom of speech. The court, however, sided with the law, saying her speech had caused clear and present danger. It follows that the same logic and decision could be applied to the Brandenburg case. Not so, said the Supreme Court. Their reasoning then no longer applied. Their understanding had evolved. The main force that invalidated the Whitney decision was a cluster of case decisions concerning the 1940 Smith Act. It's important to first understand this law and the decisions made around it in order to understand why the Supreme Court ultimately overturned Brandenburg's conviction. The Smith Act came out of a time where the stability of government was a prime concern. Forces like Nazis and soon after communism threatened the American way. The Smith Act was a federal law attempting to give legal teeth to fight those voices. Its clause that came into question was, quote, to advocate the violent overthrow of government. What does that actually look like? The following three cases are imperative as they show the progression from the clear and present danger test to the need for something more specific. First up was the 1951 Dennis versus United States. The background of all three cases is similar. Communists stood accused by the Smith Act for advocating government overthrow. Was their right to free speech abridged? Concerning Dennis, the Supreme Court said no. Clear and present danger created by his words was, quote, not improbable. Not improbable. Based on this case alone, speech isn't just punishable if it's going to cause danger, it's punishable if it could. The Red Scare had legal authorities wielding the Smith Act as a catch-all silencer, and the Supreme Court essentially gave them the thumbs up. The Dennis decision was an overreach of free speech restriction, and its glaring disregard for the First Amendment soon became apparent, starting with the second Smith Act decision, Yates versus United States. In 1957, the Supreme Court overturned convictions of 14 California communist leaders. Their decision made a novel distinction. There is a difference between advocacy of doctrine and advocacy of action. The Smith Act had been applied unconstitutionally, limiting their freedom of speech. The 1961 Noto versus United States decision in many ways emulated Yates. Noto's conviction was overturned, another strike against the Smith Act. The decision was quoted in the Brandenburg decision saying, quote, the mere abstract teaching of moral propriety or even moral necessity for a resort to force and violence is not the same as preparing a group for violent action and steeling it to such action. Beginning with Schenck and building all the way to Noto, this progression of common law history culminated in the Brandenburg decision. Quote, mere advocacy was not distinguished from incitement to imminent lawless action in the case of Brandenburg. End quote. Therefore, any law which, quote, fails to draw this distinction impermissibly intrudes upon the freedoms guaranteed by the First Amendment. End quote. As a result, the court created a new precedent called the two-prong test to determine if advocacy went too far, saying it had to create an imminent and likely threat. This remains good common law today, having specified that any law attempting to prevent criminal syndicalism needs to focus on the action potential and not just the speech itself.